This second half of TVC Breakfast Wednesday edition. Since 1999, Nigeria has had about 7 elections, but way before that, the country has dipped in and out of democratic system of government. Here are some figures and facts on the petitions filed by aggrieved candidates in some of these elections till date. Of course, every election or presidential election result in Nigeria, except for that of 2015, has been challenged at the court since 1979, 1983, 1999, 2003. Of course, the presidential election was also challenged in 2007, 2011, 2019, and 2023, which we are in now. And this cycle of election, the petitioners are Atiku Abubakar of the PDP and Peter Obi of the Labour Party, both men challenging the results of the presidential election victory of Bola Tinubu, who's of the All Progressives Congress. The judgment is being delivered exactly about 170 days after the filing of the petition, which is now just about 11 days shy of the 180-day time frame set out in Section 285, subsection 6 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. And these amendments stipulate that election petitions should be disposed of within 8 months from filing to the appeal stage. These amendments are contained in Section 285, subsections 5, 6, and 7. Let me read out subsection 5. It stipulates that the election petition shall be filed within 21 days after the declaration of results. And subsection 6 adds that it allows for the disposal of an election petition within 180 days. That's about 6 months. Subsection 7 is clear that an appeal shall be heard and disposed of within 60 days from the date of delivery of that judgment. So this means that after today's judgment by the presidential election petition court, losers can, if they wish, file an appeal, but that appeal must be disposed of by November the 6th of this year. So that's all what we'll be discussing this morning, the issues surrounding it with the heightened anxiety now that today is Judgment Day. I have with me in the studio 2 lawyers, social development advocate and a lawyer. Olatubo Soshifowora is here. We also have a lawyer and a PR consultant, Jide Ologun. It's good to have you join us, Mr. Ologun.
Thank you very much.
Good to see you both,
Pleasure.
And I hope you've been keeping well during this period. But looking around, there had been so much talks about an anxiety, understandably so to speak, ahead of today's judgment at the Court of Appeal this morning. But then all the parties are saying no shaking. Still, they're saying no shaking. But when you look at the security permutations on the ground, before we even get to the security permutations now, what are you looking out for? As that judgment will get to be read today, what would be the areas of concentration or interest for you?
Basically, we expect one of three options. Option 1 is to affirm the victory of President Tinubu and our Commander-in-Chief. Option 2 is to nullify that victory and call for another election. And option 3 is to nullify, ask him to leave office, and instate one of the petitioners who the tribunal eventually decide won. You see, so those are the three options. And by the end of today, we know where we are going. But having said that, when it comes to contentious issues like this, when you allege, you must prove. That's what the Evidence Act says. So it's not about the allegations of eligibility, double nominations. When you allege, you must prove. And I think about 89 senior advocates of Nigeria have represented the parties at the tribunal. So I expect that with the caliber of knowledge they have, none of them should come out to say the tribunal has not given justice, because we have monitored You can present you bring your oral testimonies, your documentary evidence, and when it comes to adjudication, we talk about issues, we talk about facts, we talk about evidence. And they've been given opportunity to present all this before the tribunal. And the tribunal, having 5 justices of the appellate jurisdiction level, it's not a mean thing. And I want to say this as a matter of fact, that the judiciary cannot be intimidated. You know, it's just interesting that we are now in an era of social media where there are several tribunals on phone. In fact, some have concluded this matter weeks ago. But it's not like that. And let me also commend all the parties before the tribunal for testing democracy. You see, and if they did not have trust in the judiciary, they would not have gone. The judiciary will not come and say, yeah, you must come to the tribunal. No. In 2015, the former president, Goodluck Ebele Jonathan, was an incumbent president. And he decided that, okay, let me submit to the decision of INEC. And constitutionally speaking, INEC is the mandated umpire to handle elections in Nigeria. But if you look at Section 65 of the Electoral Act 2022 as amended, it keeps the door open that, okay, if you are not satisfied with the final decision, you can approach the tribunal or a court of competent jurisdiction. So by and large, we are testing our democratic processes, and as of today, within the time given for these matters to be resolved, we come to hear the verdict. Now let me say this, I don't envy the judiciary at this point in time. Somebody must win. So it doesn't, in politics, you know, your party must flex muscle just like in wrestling. We will win. So 3 major parties now are saying they will win. So let's wait as spectators, and at the end of the day, we, hoping that the tribunal will see to give the final verdict. And we move on. Like Femi Falana said, there is still the Supreme Court intervention after this level.
I still want to ask you, before I compare notes with that of Osun Oshifora, your co-analyst, and that is, going by the introduction, the fact that, and you've said as much, that the judiciary is up to the task. This will not be the first time that the judiciary will have to adjudicate over, presidential elections. Statistics take us back to as far back as 1979. And, this is yet another round that this, senior jurists will now have to determine the fate of, the incumbent, so to speak. But what do you make about this particular cycle of duties, of national duties for the judiciary? When you look at, and even beyond judiciary, what makes this one, stick out? Would it just be any other activity for the judges or even for us as a country, or does this stand out somehow for you?
There are 3 arms of government. The legislative arm, they make the laws. The executive executes. Judiciary interprets. The judiciary will not force you to come for the interpretations of the law. And I've mentioned it. These parties went to the tribunal. In fact, it's affecting the civil cases. Many judges have been drafted to go and attend to election petitions. You see, so it's not, and that is kept open because the judiciary is reckoned with as having the capacity to look at allegations and resolve disputes there and come to a conclusion. And talking about INEC, the foundation of INEC dates back to the pre-colonial era, but basically we have the Federal Electoral Commission of 1960 that conducted the 1964-1965 elections, which was even rancorous. So I also do not envy INEC. So maybe what we should be looking at now is go back to our laws. I throw it back to the National Assembly. Section 4 of the Nigerian Constitution 1999 as amended says that the National Assembly shall make laws for the peace, order, and good governance of Nigeria. So to say, okay, maybe in 2027, rather than waiting for 180 days to dispense with petitions from elections, let's have 14 days, even before the winner is sworn in. Issues laws. Is the laws you have made that will be interpreted. You see? And so it's not as if the judiciary is just jumping on so moto to say we'll be the one to decide who the winner of elections is. No! If these parties had not come, after all, I think one or two parties withdrew from this. It's not just Labour and PDP. They just insisted to go ahead. And the gate of the Supreme Court is still open, subject to the final decisions today. But let me underscore this. All the parties have been given premium attention to present their case. And in law, you have to prove your case. You see, so, and I don't want us to be sensational about it. I have refused to be sensational about it. Maybe perhaps because I'm a lawyer, because we were taught in law school, you focus on issues.
That's right.
So, I mean, to save your time, and they say you keep your gunpowder dry. There are several allegations from different camps. Then the justices will sit down and deliberate over them and come to a conclusion. So the judiciary is not determining the results of elections in Nigeria, please.
Right, and so this year, if we look at looking at how far Nigeria has come in terms of election petitions of this magnitude, it was a three-party petition, so to speak. In 2007, the ANPP-AC, the PDP, it was also three parties who were slugging it out before the election petition tribunal. Okay, that was 2007 between ANPP, AC, and the PDP. And now we are seeing it again. Even in 1979, the UPN, NPP slugged it out with the NPN before the NPN carried the day. And now we're having another semblance of a three-party battle, so to speak. There is the ADP, as Mr. Ologun has said, three parties are slugging it out against the APC's candidate. But what are you looking out for today? So many issues have been outlined when you look at the case of the PDP, the Labour Party, and the APC, so to speak. But in terms of how this case stands out, when you look at how it has trailed back in time, what is, how do you reckon?
All right. First off, let's start from what you said. I think Mr. Ologun pointed out, it's out there that certain parties pulled out after filing the petition. I think if we go scriptural, there's a part of the scripture that says that nobody starts building a house without counting the cost. So I think for the parties that actually withdrew, they must have looked at it that, come on, what are our chances? Then where do we fall? I mean, if you're talking about, I think one of the candidates, I think it was Peter Obi, that had about 6 million. Atiku had 7 million. Asiwaju had 8-point-something million. Now, so you with 100,000 votes, I mean, common sense speaks to the fact that this thing is not likely to go in your way. I mean, the worst case scenario, even if we will, people have alluded to the Uzodinma situation. We saw how it came on, and how the votes were recounted by the courts and all that. Now, so for the parties that pulled out, I guess they counted the costs and decided that this thing, whichever way it plays out and pans out, is not going to go in our favor. So they stepped back, leaving the big three to slug it out.
Let me put you on a hold. We'll come back. We need to take a crucial break, and then there'll be more on TVC Breakfast. Please stay with us. I've been speaking with Bosun Oshifowora and Jide Ologun, both lawyers, to share insights on the matters at hand. There are crucial controversies that are due to be settled somewhat by the judges, by the justices of the Court of Appeal when they come in to deliver this ruling. In the meantime, you were making a point about, it was initially 5 or 4 parties sending in petitions against the APC's candidate, and now it has, been reduced to 3. It was 5 actually. Now we have the PDP, the Labour Party, and the ADP party. So you're making the point.
All right. So they must have counted their cost and looked at it that this is not where we want to go. And I think Mr. Ologun said something profound when we started this thing. 3 things can only happen here, nothing outside the 3. First, they affirm the sitting president's position that he was validly elected and sworn in. Secondly, they may withdraw his mandate and ask for a rerun. amongst the first two candidates.
In fact, a party is saying they don't even want the APC candidates on the ballot if the court decides.
So the court will now tell you who and who, because even the Constitution provides for a rerun. Rerun is actually between the first two. Now, so that's another dimension to it. So if they're asking that the first candidate be taken out, maybe they want the rerun between the second and the third. Now, so the first thing is they affirm the sitting president's election. Second one, a rerun, or they replace him with one of, they take out the mandate of the sitting president, then replace him with one of the petitioners, depending on how the court deems it fit. So these are the three things, these are the three areas. And then also, I think another major point that was put forward earlier by Mr. Ologun was that laws are not based on sentiments. It's based on facts. It's based on evidence. And then they had ample time to prove all their things. Now, a few things that were raised. And you see, this case also is going to settle some constitutional issues. The issue of 25%. You know, this thing, funny enough, has been recurrent and recurring. You remember 1983? It was Aulo and Shagari, Richard Akijide coming in, the 12th to 3rd was the actual, position. Now, this time around, based on the 1999 Constitution, it talks about 25% in 2/3 of the states and Abuja. Now, so the court is going to help us to actually put paid to that issue of and. Now, we've had instances where the court, even the courts and the Supreme Court also have expatiated on the use of and, use of shall, use of may, and how these things, and all these things, how they work. So we're going to go in for a bit of not just semantics now, but how law works in regards to certain usage of some things that we're used to, because the court here is going to interpret and how it works as far as this petition is concerned, because it's a germane part of what's on ground. Because some people, certain petitions have alleged that the sitting president didn't win in Abuja. And then also we've had all kinds of explanations, legal explanations, where people have come to say that and says that it's 37 states. Some say and distinguishes, Abuja, and that means that you have to. So definitely that's a major point that I think a lot of people are focusing on. As for another part also is the uploading of the results in real time and how it affects it. Though there's been some court decisions in that regard, but everybody's looking up to the appeal court. And you know the way it works with presidential election. They don't start from the lowest tribunal. They start from the Court of Appeal. Then the next place is the Supreme Court, which is not going to have much to do. The Supreme Court will just look at the judgment and decide how to. That's why you have shorter time for the Supreme Court to determine what so it's at the appeal court level where they are now, the presidential electoral petition level, which happened at the appeal court. That's where parties for the presidential election were able to prove their mettle, bring their evidences and facts, and corroborate whatever the other person is saying or dispute whatever the other petitioners are saying. So at this level, once they're done here, I think we should appeal or make people understand that it's not final yet. The Supreme Court is still there. So whatever the decision here, they're still taking it a step further, depending on the candidates. We just talked about the fact that certain persons looked at it and decided to opt out based on how they fancy their chance at the tribunal. So going forward, you may see one candidate still saying, no, I'm not satisfied with today's decision. Then there's still the option of Supreme Court for this presidential electoral petition. Then both candidates may go ahead, or the other three parties may decide to go jointly or whichever way, but there's still a step further beyond today. So whatever happens today, the parties will have to go and sit down, review their situation, review the judgment, possibly ask for or seek further interpretation and explanation on how the judgment favors them or how the judgment is against them. In fact, not just the three parties now, because I'm not preempting anything, all the parties, they will look at how the judgment affects them, because you don't know what the court is going to come up with, and nobody has seen the judgment except the judges. So they're in the best position. So once it's read, then that's when we can now make, opinions and now make headway of what has gone down and how everything has been explained. So that would determine the next step for all the parties.
All right. Mr. Ologun, two issues for me from what Pastor Shifora has said so far, and it is now narrowing or looking at two major issues that are bound to form part of, today's judgment, and that is the issue on whether there was substantial compliance on the part of INEC with the provisions of the Electoral Act in determining president or determining Bola Tinubu as the winner. And then there's also the issue of what status should be accorded the FCT. And I want to compare your thoughts with that of Boso's now, how much you think this may form a precedence, judicial precedence, so to speak, or a precedence generally in the future, in the nearest future.
Judicial precedents are to guide us. But I can tell you this about litigation. Lawyers play with precedents. You see, they still come with the same, what the court has interpreted 7 times will still be brought before the court for interpretation. So I came up with an argument at a time, and I hope it is entertained. I mentioned earlier that Section 4 of the Nigerian Constitution 1999 as amended says that the national assembly shall make laws for the peace, orderliness, and good governance of Nigeria. So if the case of Abuja remains a contentious issue, despite the judicial interpretation that has been given, then go back to the chambers and tell us whether Abuja now is a federation on its own and more powerful than the 36 states, or is one of the 36 states. Let's have clear pronouncement in the law. For example, the amendment to the Electoral Act specified if you are a political appointee and you want to be involved effectively at the primary level, you resign from office. We have tested that. We are testing the one that has given the time frame to resolve electoral issues. And talking about the other one, about INEC, my argument has always been and remains that despite all that has been provided for, INEC still has the latitude to exercise discretion. So what do we do with that? Do we now come up with a law specifically that says, okay, any result that is not transmitted so is automatically cancelled? Laws are made for the society. But in the absence of that, INEC will tell you, we can make our guidelines, we can do this and that. So these are specific issues. If we must move forward, no law is static. America must have reviewed their laws several times. So as we navigate in the course of life, you amend your laws to cope. For instance, when COVID-19 came, new regulations came up, new normal and this one and that. So let's learn from this. And a senior advocate raised a critical issue that we're even still ignoring. If you read Section 65 of the Electoral Act 2022 as amended, it gives INEC the liberty to review some concluded results within 7 days, or you now go to the tribunal. So these are issues. So let the legislative arm listen. These 3 arms are expected to operate as a symbiotic team to move the nation forward. So, and these are issues that the tribunal will consider. There are several issues of double nomination, issue of a candidate not even being, being a member of that party when he came out to court, several issues. But we leave all those issues to the tribunal. But I personally trust that tribunal. We are talking of 5 justices. You must have taken the pain to look at the case of Adeleke. At the tribunal level, the decision was not what took place at this. So you have legal minds that will look into all these facts. But I echo that if you have alleged, you must prove. And sensationalism has nothing to do with law. And permit me to bring the precedent of Ekwuremadu's case in the UK. If sensationalism has a role in law, then the letter of Chief Olusegun Obasanjo would have made UK to say, Ekuremadu, go back to Nigeria, continue as your honorable, the efforts of ECOWAS. In fact, in the case of the former governor of Delta State, very interesting case. A team went from Delta State to try and persuade the court that the former governor built Olympic-sized stadium in Delta, and the judge said, my business is not to assess his performance in office, but to jail him for specific crime. You see, so we have, parties have submitted to the tribunal. Don't let us intimidate. The tribunal, the judiciary cannot be intimidated. I mean, I sit here to say that. Because by the time we get to that point, then where do we turn? But I respect the sentiments of people, which is natural. And that's why I use the analogy of wrestling. When you see wrestlers in the wrestling ring until the battles are over, each one is harassing the other. I will knock you out in 5 seconds and things like that. But there's a referee there who holds the whistle to, navigate the exercise. So these are issues.
You both have spoken about the 3 possible scenarios that may play out today. The issue of the Tinubu victory being affirmed, or that the court would, take it away and possibly order fresh elections. And that also forms one of the prayers of one of the contending parties. But social media and even, regular discussions have said no reasonable court would order fresh elections. But I don't know where you stand, or if you still insist that all options are still open before the judiciary. Let me ask you.
It's amazing how the social media has come to be a part of what we do now. It has its own pros and cons. But you see, law is a very conservative realm and regime. And the law is not perturbed. I think Mr. Logan has stressed countlessly that you cannot intimidate judiciary. Then secondly, sentiments don't work with law. It's amazing how, sometimes and I think that gives room, or gave birth to the fact, or to the expression where people look at lawyers and say, these guys, lawyers are liars. And the reason why people say that is because the way they have viewed the thing from the layman's point of view, by the time you subject it to the law and the process of the law, you find that the law will come up with, sometimes the law may come up with a decision that is diametrically opposite your sentiments and sensationalism. Now, so the social media can say anything. That remains in their realm. The realm of law, it's a different realm. It's a different regime. And these are laws at that level. They're not just bringing out new laws or saying new things or saying things that sentiments on the street. No. We're going by things that have been tested. We're going by a process that has been over time. And like it was pointed out in the course of this discussion, whatever the outcome of today's judgment, or whichever way the judgment goes, is going to be predicated on what has been proven. There's a saying in law that the court is not a Father Christmas. It's not going to give you what you didn't ask for. The court is not going to give you, if you were not able to prove some things, the court will not look at it that, and if he had gone a step further, maybe, okay, let's help him. Court doesn't patch for people. It is what you have brought forward. And if you look at all the past judgments, I mean, let's look at you went down memory lane. It was based on what they presented to the court. Even if the court can see that you just need to push a little bit, the court won't push for you. It's what you presented. And so some people should be ready for some shocker today in almost all the quarters. So, and then what I just feel is that whatever happens, go back, sit down. In a few days to come, we will still come back and analyze the judgment. And then we'll dissect it, and you will see how everything... But one thing is clear, law and sentiments don't correlate.
All right. Mr. Logo, what do you think? Do you still want to go for, all options being open, or do you see a possibility of fresh elections?
Subject to the tribunal, if I mean, but we also need to review the budgets of the because if the tribunal orders a fresh election, Nigerians are the ones that will jump out and say, who is going to finance it? But let me say this, like someone said, if you claim that education is expensive, you may try ignorance. The other option against submitting to the intervention of the judiciary is to take laws into your hands. And we know the effect of that. And I want to say this also to citizens. Please, allow the process. What we have established here today is that when you come to the justice system, you have brought allegations, you prove, the other party defends. And permit me to be scriptural like my brother. You recall the two women that brought children to King Solomon. One dead, one alive. And the King Solomon said, bring a sword. Cut this one that is alive so that the two can die. And the woman who said, no, don't do that. King Solomon said, so it's about a lot of wisdom. So I also do not envy the judiciary. It does not matter what the decision of the judiciary will be. Some will still not be happy with that decision. But we have three arms of government. We have governance structure that we must respect. And I mentioned it earlier, our democracy is being tested through judicial processes. So my submission is that the judiciary is not
okay, I just spotted, live images from Abuja, and I wanted to indicate that to our viewers. I'm sure the videos will return, but, continue, please.
So it's not the judiciary that determines the winners of elections in Nigeria. Judiciary is just waiting for those who want to come to them so that they can carry out their own exercise.
Right, and we are already seeing, like I hinted earlier, live pictures from Abuja. This is the Court of Appeal, where the panel of 5 justices will deliver the judgment in the petitions between the PDP, the Labour Party, and the ADP against, of course, with the APC being the respondents. Of course, the 3 parties are challenging the election victory of Bola Ahmed Tinubu in the presidential election tribunal. In the election, I should say, which occurred earlier in the year, the Court of Appeal has also announced that proceedings will be carried live on TV stations. So there, in the comfort of your home or even with your device, you can join in and stay glued to your set that is on TVC News to monitor, to hear, firsthand what the justices will have to say about these very interesting petitions and this development. And, that has even also brought up arguments. The Labour Party specifically saying what is different between a call for televised proceedings during the tribunal and now that judgment is to be delivered. Why did the judge, or why did the tribunal reject our calls for televised proceedings, and why has the court now said that audience, people can watch live? What do you reckon?
First off, I think one of the things we have to get clear is that you don't just wake up and start challenging the courts because this is how you feel. The court is better placed and best suited to determine how it will run its course. I think that one should be clear, and that one should be. I've seen people on social media call out judges, try to give information about certain justices, trying to, cow them. And I'm like, it doesn't work like this. Now, so at the trial stage, the justices declined, and the court said, this is how we want to run it. Now, so today they said, we will televise it, and that's it. So I don't think that is much of a big deal. And then the court is at liberty to determine how it wants to run its course. Then also, one of the things we also need to stress is that this is a Court of Appeal decision. So there's still another step. So in case you're not satisfied, in case you feel sentimental about the whole thing, there's still a second leg to this thing if your party will decide to take that leg. So it also depends on the party. But there's a second leg to this, which can actually change whatever decision. Because I remember way back in law school, there was our corporate exam. It was there was a particular decision of the Court of Appeal on, I think it was Lunge and First Bank then, that we used to do the exam. When we left the law school, the case went on to the Supreme Court. It was a different decision completely. So those who did the exam years after my set left the law school, they came up with a different answer based on the decision of the Supreme Court. So this is one leg. There's another leg to this thing, which can upturn whatever happens today. So because I've had podcasts, I've seen people say, whatever happens, we will scatter.
It even happened in the case of Adeleke in Osun State.
Exactly.
The tribunal overturned his victory. The appellate court restored the victory. You see, for looking... What the judiciary will do is to look into the matters critically. So, and that is why... But you cannot rule out sensationalism in the age we are right now. But my advice is that, you know, at that level, there may be more of assumptions than what should be. And like a wise man said, that assumption is the lowest level of knowledge. So that is why we advise that people should calm down, look into facts. And I think one of the reasons why the tribunal wants this transmitted live is that so that you can listen to. It's good to read judgments, you know. It's listen to, because they will present the arguments that have been brought before the court. And somebody can look at me on the street and say, Jide Ologun slapped me. When you take me to court, you must prove how I slapped you, when, was it with the left hand, with the right hand, what led to it, and things like that. So, and that is the beauty of the judiciary. So if I were not to be a lawyer, I would have gone back to study law. So, and these are, so these are issues. And that is why the way we live also, I'm not sentimental about issues. You need to look at it critically. But I am also advising, though the position of the law is that a legislation that has been tested judicially stays. But if you need to go back, because this issue of Abuja, we need to settle it once and for all. And I am a singular advocate that the National Assembly should please help us. It's either we now have 37 states or we now have an Abuja. And if Abuja has now become so powerful, it makes it easy. So all candidates will just go to Abuja and whoever wins there is declared. You know what I mean? These are critical issues.
No, if I may come in quickly, the issue of Abuja, like I said, is settled because the Constitution says that Abuja shall have the status of a state, which by implication makes it 37 states. It's there, I think, Section 199 of the Constitution. Now, so if he says it shall have the status of a state, that means that with the 36 states already existing, and we have one that has another status of a state, that makes it 37. But I think, like Mr. Ologun advocated, they should reword it and put it in very simple English so that "and" will still remain the same meaning that we know it has.
Right. It's really interesting, and like you both have said, it's bound to be a painstaking, you know, effort or exercise, you know, for the justices this morning when they come in, when the court convenes, so to speak, to deliver judgment on these crucial issues. And we've been showing you live pictures of happenings at the Court of Appeal this morning and indicating readiness of you know, the courts to go on, because at a point people were even wondering whether the judgment would be delivered today, even after it had been announced that today was Judgment Day, talking about the presidential election and the fact that, you know, a faction of, you know, Labour members embarked on a two-day warning strike yesterday. But from what we've seen, I spotted the former FCT minister, Bala Muhammad, who is now the governor of Bauchi State. I spotted him among the personalities at the court, you know, moments ago. Will continue to dip in and out to, you know, present the proceedings to you even before they start. But a quick word now on, you know, the heightened security presence that we see. It's not just in Abuja, by the way. It's not just, in the court. We hear that parties will be frisked adequately before they are admitted into the court premises. Even parts of the country, Lagos inclusive, have also, witnessed heavy security presence, pointing to today's judgment. What do you make of it? Is that needed?
It's needed. It's important when you look at the sensationalism. And thank you for the brilliant opportunity you brought on the table. May I just advise electorates? For those of you who have been monitoring these petitions and things like that, some of us also have been monitoring the politicians. Some of them have attended social events together. They've clicked wine glasses. Right now, we have almost a government of unity. There's a particular minister, you don't even know which party he belongs to. So, electorate, please wise up. Let me use that expression. And let's come together to demand good governance. It's important. Because after today's frenzy now, we go back to the normal, the economic situations and things like that. So, I want to advise, please, if anyone is luring you to be of violent tendencies, consider that as they have a future, you also have a future. So protect yourself. Don't be an instrument of violence or destruction. But it's important that the government should provide the security.
Absolutely. Okay. So that's your take on the security presence. So what you're seeing now on the screen, we're bringing back the results, as announced by INEC, during the presidential elections earlier in the year, with Bola Tinubu, the president, garnering 8.7 million, more than 8.7 million votes. He was followed by Atiku Abubakar of the PDP party, who polled more than 6.9 million. Peter Obi of LP is also there, placing third with 6.1 votes, more than 6.1 votes, I must add. And that's Rabiu Kwakwanso of the NNPP, who polled more than 1.4 million votes. But we are seeing, Mr. Peter Gregory Obi and Atiku Abubakar, who are, insisting that, insisting, yes, that's the word, that the victory of Bola Ahmed Tinubu, should be annulled. But it's interesting, one is saying the second and the third are claiming victory in that election, and it won't be the first, by the way, as we have already said. But it's really interesting as when you look at it. Awesome.
You look at your chances, and you don't blame anyone fancying his chance to be anything. Now, but no matter how much you fancy your chance, it is subject to the law. It is subject to a particular process. It is subject to litigation. It is subject to facts and evidence that you can present. Because some of us followed the trial and we saw how things panned out. And if you look at some of the prayers, I've had people say the petitions were washed and all that. It's not. Because if you look at some of their prayers, they've been careful in crafting and drafting their prayers. Because someone had looked at it that, okay, fine. If I cannot prove that I have this amount of votes that supersedes who has been declared the winner, then, okay, let's come from this angle. Why don't we take the winner away? That's why you find one of them pray that, see, this person that was declared winner, he's not qualified to be the winner. Take him out. So when you take him out, then that gives you, because I explained earlier that we run is not amongst three persons. Is amongst two, the last two.
Right.
Now,
so the first, okay.
Yeah, first two. Now, so what happens is, if you take out Bola Ahmed Tinubu, that leaves you with Atiku and Obi. So whatever, if rerun happens, let's say it's taken out, then rerun will be between these two. Okay. Some other candidates also have looked at it that, okay, the best thing is this: just take this man out of this equation, or even if. Because the way it works for me, the way it works with the law is that if you say you won, all you need to do is present evidence that, okay, this person had 8 million votes or 8.7 million votes. These are my votes. These were not counted. These were invalidated, but they are supposed to be valid. if you count everything, put it together, I have 9 million votes, or even 8.8. If you could prove that, then you'll be declared winner based on what you have presented. But where you see that you can't present votes that will supersede the person that was declared winner, then you have to come up with some other strategy, which they have done, and which I admire, because, like you said, 89 SANs, 89 SANs coming up. The brilliant argument, and sincerely, we're in for a brilliant judgment. But the thing is, I need to warn people, judgments are not something they read in 30 seconds or 30 minutes. You're going to sit for 6-5 hours.
When I said painstaking, I wanted to. It's good you mentioned that.
So if you're going to eat well and sit down, if you don't want to miss any part of it. But right. I know sometimes to non-lawyers it can be tiring because you don't get, what are they saying? Sometimes you see some repetitions.
And there is even need for caution because the courts, they are going to begin with the arguments
from the beginning
of all the parties, down to the littlest
that's
argument.
The point I'm
don't
saying.
Run if you're observing online.
May I advise those who are keenly interested should sit down this time around and listen to this argument. They have all been given the opportunity. So, and if you don't present your case well, even when you have a good one, who do you blame? Recall the case of Shylock in a merchant of, that went to court that, okay, I'm entitled to a pound of flesh. You've not paid my money. And they got to court, and the lawyer said, it is true that on paper you are entitled to a pound of flesh, but it is not written in that contract that you can shed blood before having your pound of flesh. So go ahead, get your pound of flesh, but please don't shed blood. These are things people refer to as technicalities. So law is interesting. That's why I said the other time, you keep your gunpowder dry. You are likely to have gone for 75%, and the other party brings in an issue at the point of 77% that knocks off your 75%, and you are in the rain saying, how did this happen to me? So it's quite interesting. Let's trust the judiciary. But above all, please calm down. Beyond the frenzy of today, there is a need to come together and advocate for good governance in Nigeria that will generate commonwealth for common good and put us on the path of prosperity. So once again, I congratulate all the parties who have taken the pain to go before the tribunal, giving muzzle to our democratic system. Right. And of course, it must be stressed. And, I like the fact that you both have, also put that in your contribution so far, that there will be, it's going to be a long sit or it's going to be a long wait, so to speak, before the court makes its final decision, looking at how many documents are involved, how many pieces of evidence are involved, which the courts will start with. And just for a non-lawyer who is observing from outside, it's important to stress that you must wait till the very last word has been said before you now say, okay. Again, is subject to the discretion of the court. There is little we can do about the sensationalism on social media. We had a case that went all the way to the Supreme Court for 15 years. And the decision in the Supreme Court, when it was being read, didn't last for more than like 17 minutes, So we won anyway. So, so you can imagine a business of 15 years just concluded in 17 minutes. And of course, from 1963, when we became a republic, if you are not satisfied with this case of Supreme Court, then you go to God. Before 1963, you could go to the Privy Council of the Judicial Commission of Britain. So these are issues before us. So please, great Nigerians, calm down. Politicians are friends, so don't get violent because of them. I can offer that for free.
Then there's always a chance. There's another election, you'll be a part of another.
Some don't want to hear that.
Unfortunately, you even have a choice.
But that's the reality.
If you look at it, I think one of the things that was stressed
All right, gentlemen, I'm sorry, we'll come back to this point now. We'll take a break and then continue with more on the wait for the presidential election petition court to deliver its judgment.